Hey there, I was working with a couple from Metairie yesterday working on their estate planning. A couple in their late 60s, had 3 adult children. They had worked hard, accumulated assets over their lifetime. What we quickly realized was because they had no will, no trust, no estate legal documents in place, if one of them were to die based on what they owned, there'd be about $5 million of estate tax due, and that tax would be due within 9 months after the first spouse dies. What we realized we could do is we could have them sign wills or trusts so that when one of them died, there wouldn't be any federal estate tax due. And the reason that was the case was because our Louisiana law that applies when a married person dies doesn't permit this marital deduction to take place, because the estate tax laws are set up so that if you have things set up the right way, when the first spouse dies, no tax has to be paid. You can essentially postpone it or defer it until the surviving spouse dies. But when you have a married couple and they have no wills, the Louisiana law doesn't qualify for that marital deduction, so families have to pay a lot of tax when the first spouse dies. Bottom line there, make sure if your assets are such where the value of what you own exceeds those applicable exemptions, you got to have some things in place to be able to avoid tax at the first death. If you have questions about that, call 866-491-3884 and you can talk to us about what you need to do. Have a good day.